Hello viewers, I am Dr. Shivani Gupta from the University Institute of Legal Studies, Punjab University, Chandigarh. It is my pleasure to welcome you to this session on an intriguing topic in the law of property, that is transfer of property to and by companies. This topic delves into the fascinating interplay between transfers carried out between companies, by companies or to companies. The parties to such transfers are either an individual on the one side and a company on the other, or two or more companies on either side. We shall be studying when transfers can be made by and to companies, the essentials and the procedure to these transfers, and the kind of interests that get transferred. There are various laws that govern the transfer of property by companies, like the Transfer of Property Act 1882, the Income Tax Act 1961, the Companies Act 2013, the FEMA rules, etc. These laws do not only regulate property transfers made by corporations, but also outline the legal requirements and essential steps for a successful transfer. For instance, if a foreign business obtains the required authorizations and conforms with all relevant regulations, it is permitted to purchase real estate in India, provided it submits within 90 days following the date of acquisition a declaration to the Reserve Bank. Since the Transfer of Property Act 1882 defines transfer of property as an act of passing on property to one or more living persons or to oneself, thus it also includes in its ambit transfers by companies and corporate houses. The Income Tax Act 1961, on the other hand, defines transfer as the sale, exchange or relinquishment of a capital asset. A transfer of property to and by companies is the legal procedure through which a business either buys or sells a property it already owns, such as land or buildings, in accordance with the rules set forth in the applicable company law and the transfer of property law. It is the legal procedure by which a person or organization transfers ownership of a piece of property, such as real estate, buildings or assets, to a corporation, effectively establishing the corporation as the new legal owner of that property. This is typically accomplished through a formal deed or document that is filed with the appropriate authorities, frequently as part of starting or growing a business. This process usually applies to all entities, including big and small businesses or corporate houses. In essence, it is the purchasing or selling of real estate by a corporate entity. Now, let us see what are the types of transfers to or by a company. First one is sale and purchase. Using a sale deed, a business can transfer ownership of its assets to a different organization. That is, it can sell or purchase real estate to or from a person or another business. Sales and purchases must be registered to make them legally effective. The next one is a gift. Although this calls for certain legal considerations, there are circumstances in which a business may give property as a gift. This is, however, not a very commonly practiced mode and involves specific tax implications as contained in the company's Articles of Association and company's stamp duty regulations. The next category is a mortgage. By mortgaging its assets, a company can utilize them as a security for a loan. Next is a lease. Under predetermined conditions, a firm may lease property for a predetermined amount of time, also specifying the rent. This has become a very common practice in the recent past, especially for using the premises as warehouses, godowns and even offices for the company's employees. Next is assignment. For transferring property rights to a business or corporate house, an assignment deed is a must document. Next is transfer through partition. The immovable assets or real estate held by a company may be transferred to shareholders or other corporate bodies during its dissolution or partition. Acquisition for business activities. Various business activities like establishment of manufacturing units and offices requires the corporate houses to acquire real estate. Next, we will discuss the highlights on transfers to and by companies. The first thing is company experts. Transfer of property by a corporation must be effected only by authorized personals like officers or directors who shall also require suitable board resolutions to bring about the transaction. Next is company constitution. The extent to which a company is authorized to transfer, including sale or purchase of any property, is determined through the provisions and terms laid in its memorandum of association termed as MOAs and articles of association termed as AOAs. Next is observation of regulations. Depending upon the jurisdictional laws applicable on the company, some additional permissions or registrations may be required for transfers pertaining to certain corporate units. The transfer must be approved by the board resolution and the company must authorize the performance of the required actions. It is important to note here that in the event of transfers involving foreign companies or non-residential entities, the requirements of the Foreign Exchange Management Act, abbreviated as FEMA, must be accomplished. Next is due diligence. It is possible that the property proposed to be transferred may not have a clear ownership or may be subject to certain legal encumbrances. In order to prevent such property from being transferred, a business should mandatorily carry out extensive due diligence processes prior to such transfers. Further, an appropriate attorney must be consulted well in time to transfer the property legally and appropriately. This shall include paying for both legal advice and preparation of documents. Next very important aspect is deed preparation, stamp duty and registration. The transfer deed must contain the detailed terms and conditions of the transfer, be it a sale, gift or lease. Generally, a deed of conveyance is prepared. It is a document that identifies various aspects like the property to be transferred, the corporation that is to receive the property, the party transferring the property and the terms of the transfer. This deed must be stamped in accordance with the stamp duty regulations that are applicable in the concerned state jurisdiction, followed by its registration with the sub-registrar's office. Next is consideration. Consideration is a prerequisite in all transfers unless it is by way of a gift. Wherefore, even in this case, the transfer must be accompanied by a legitimate exchange of value either in cash or kind, which is usually company stocks or shares. It is important to note here that a company may trade its own shares for real estate provided it abides by the provisions of the Income Tax Act 1961 and the Companies Act 2013. It is necessary for the company to get permission from the shareholders and the board of directors. Further, to ascertain the amount of consideration for the property, the worth of the shares needs to be ascertained through a certified valuer. Next, implications for income taxes. Such transfers may lead to tax liability like capital gains under the provisions of the Income Tax Act of 1961. Now, the next question that arises is, can a company transfer its property to an individual, that is maybe its director, or can a company purchase property from an individual? And if so, what are the necessary implications to carry out such transfers? The answer is yes. It is possible for a company to transfer its property to an individual or to even get a property transferred from an individual in its favor. Following are the administrative and legal necessities that must be fulfilled to successfully carry out this process. The very first one is examine the company's documents and policies. Whenever company's assets are to be transferred to its directors, etc., the company's articles of association and other applicable internal policy documents must be consulted. Whether the proposed transfer is allowed in the given circumstances must be verified by these documents. The second important aspect is assessment of the immovable property. To ascertain the fair market value of the property, an independent evaluation is desirable. This will not only help in securing a fair deal, but will also protect the business from any possible legal concerns. Next one is board acceptance. No transfer can be accomplished unless it is done with the prior approval of the board of directors. Such an approval is obtained during board meetings, the primary of which is to discuss and vote on the details of the transaction. Thus, it is suggested that the minutes of such meetings should be noted appropriately and correctly. Next is creation of a sale agreement. It is necessary to create a sale agreement that contains the detailed conditions attached with the transfer. The agreement must contain the sale price and terms of its payment. Further, depending upon the jurisdiction it is subject to, it is necessary that the contract must conform to the regional requirements. Next aspect is shareholders' approval. This is but optional. That is, it is not a necessary step and its requirement may depend upon the nature of the business and the importance of the transfer. This, however, becomes important if the property is an important asset of the business. Title transfer. A transfer is only complete once the necessary documents are ready that shall have the effect of transferring the property's title. This involves the submission of transfer documents with the local land registration body. Tax considerations. A transfer may have serious implications on the director's or company's tax liability, whereby such changes must be taken into account. Such tax considerations may involve stamp duty during transfers, capital gains tax or other taxes. It is thus suggested that due guidance must be had from a tax advisor. Next is speak up with the legal consultants. The advice of a legal and financial consultant must be resorted to at every stage of the transfer process to make sure that all actions pertinent to rules and regulations must be adhered to. Updation of company records. Once the transfer is complete, necessary changes, either additions or deletions, must be made to the asset register and the company's accounting records must be appropriately updated to reflect the sale or purchase. The next aspect is legal adherence. The observance of all local laws and rules affecting property transfers by companies and directors is a must. Let us try to understand this all with the help of an illustration. Let us say there is a private limited company. Let us say the hypothetical name is CAT Private Limited. It decides to apportion a part of its land to one of its outgoing directors as a superannuation benefit. The transfer can be determined legally by observing the following procedure. Firstly, the company would pass a board resolution approving the transfer in favor of the director. Then, a gift deed would be drafted specifying the terms of the transfer. The deed must then be appropriately stamped in accordance with the pertinent stamp duty laws before it is registered with the registrar of deeds to make it into a legally binding document. Similarly, if Mr. Sharma wants to transfer a part of his property to CAT Private Limited, they will first enter into a contract and agree upon the terms of the sale, detailing the transfer. Then, CAT Private Limited would pass a board resolution to approve the purchase. The transfer will be completed with the stamping of the sale deed, followed by its registration at the sub-registrar's office. Basically, what are the motives behind giving property to a corporation? The motives are threefold. First is asset protection. The owner may be able to protect personal assets from business related liabilities by incorporating their property into a corporation. Second is tax benefits. Giving property to a corporation may have tax benefits depending upon the applicable local laws. And third one is estate planning. One tactic to control the distribution of assets following the owner's passing is to transfer property to a corporation. Next, we will understand transfer of property through acquisition. A corporate strategy known as an acquisition occurs when one business buys another business or its assets. This procedure is frequently employed to broaden market penetration, acquire new technology, boost productivity or eradicate rivalry. Thus, transfer of property during acquisition by a company may be described as a legal procedure whereby a business purchases an asset such as land or buildings from a previous owner as part of an acquisition. Typically, this is done through a purchase agreement in which the seller, that is, the previous owner, transfers the property's title to the acquiring business in exchange of payment and after completing the required legal and regulatory requirements based on the jurisdiction. Particular situations in which a property transfer takes place during a business acquisition includes amalgamations or merger. That is, when two businesses combine, the acquiring business receives all of the acquired business's assets including real estate. Asset purchase agreement, that is, a business buys particular assets from another business including the transfer of pertinent property titles and share acquisition, that is, the acquiring corporation indirectly acquires ownership of the target company's assets including real estate by purchasing a controlling interest in the business. Next is transfer of property during mergers. A merger is a strategic process where two or more companies combine to form a single entity. This process is often driven by the desire to achieve various business objectives such as expanding market reach, increasing efficiency and gaining competitive advantages. Sections 230 to 234 of the Companies Act 2013 lays down the procedure for mergers and amalgamations. The property of the transferor company is transferred to the transferee company when two businesses merge. This covers both immovable and movable assets, including debtors, business, machinery, stock and land. If the transfer includes some sort of tenancy rights in it, it is important to receive the consent of the landlord. It was held in the case of Brookbond Lipton India Limited 1998 judgment that because the transferee entity, that is, the merged corporation, differs from the transferor entity, a deed of assignment of leasehold rights must be executed separately and there is no such automatic assignment of tenancy rights. It is important that the merging companies must apply for approval from the National Company Law Tribunal, that is NCLT, in the state in which they have their registered offices. Next, we will study transfer of property during demerger. A corporate restructuring process known as a demerger occurs when a business divides its operations into two or more separate businesses. This is frequently done to concentrate on key business areas, unlock value or streamline operations. In a corporate demerger, all assets and liabilities associated with a particular undertaking of the demerged company are not sold, but only transferred to the resulting company in accordance with the scheme of arrangement as per section 2 subsection 19 AA of the Income Tax Act 1961. At the book value that was recorded just before to the demerger, this property becomes the new entity's asset. This transfer is treated as a going concern activity because it takes place without any further transactions. In its July 23, 2012 ruling in the Indo-Rama Textile Limited case, the Honorable Delhi High Court held that in a demerger, it is not necessary to transfer all common assets and or liabilities related to the undertaking being demerged as long as the transferred assets and liabilities alone constitute a functioning business and the business can continue without interruption. In proportion to their interests in the demerged company, shareholders of the demerged company receive shares in the new business. For instance, when two separate business divisions of a company decide to demerge, the demerged undertaking or one of the divisions transfers all of its assets and liabilities to the new company or the resulting company. The existing shareholders receive shares in the new company according to their ownership in the original company. Next is transfer of property during winding up of a company. According to the majority of company laws, any property transfers made by a company after the winding up process has begun are deemed null and void unless approved by the court or liquidator and made in good faith for a fair price and in the regular course of business. If not done in good faith, the company's transactions in the days leading up to the winding up petition may be deemed voidable and revoked by the liquidator. In some circumstances, if the court determines that a particular transfer of property is required for the benefit of the creditors, it may permit it during winding up. Next, we will study transfer of property in a company liquidation. The process of closing a business and allocating its assets to owners and creditors is known as liquidation. It usually happens when a business goes bankrupt or when its owners opt to shut down for other reasons. The Insolvency and Bankruptcy Code of the year 2016 is the main statute that deals with matters pertaining to liquidation of companies and regulates property transfers during liquidation. Since the main duty during liquidation is to collect all assets and divide them equitably among creditors, any property transfers made by the company during this time are typically regarded as null and void unless the liquidator has given their express consent. In other words, the company is not permitted to freely dispose of its assets without following the correct legal procedures. Once the liquidation process commences, the court-appointed liquidator assumes control of all company assets and becomes the only person who has the power to determine any property transactions. In the case of Alchemist Asset Reconstruction Company Limited versus Moser Bear India Limited 2019 judgment, an application was filed by the liquidator under Regulation 33(2)(d) of the IBBI Liquidation Process Regulations 2016 for seeking prior permission to sell the assets of the corporate debtor by means of a private sale. The adjudicating authority considered the issue whether all the requirements of clause A to D of regulation 33 clause 2 are required to be fulfilled to sell the assets by private sale. It was held, to our mind, the proper interpretation on clauses A and B would be that a liquidator is entitled to sell the assets without requirement of prior permission after reaching the conclusion that the assets are perishable and it is likely to deteriorate significantly in value if not sold immediately. Otherwise, the purpose of regulation would be defeated if the time is required to be spent in filing an application and taking permission because the assets which are perishable may not remain available for sale and perish, or it may deteriorate significantly in value if not sold immediately. However, the adjudicating authority must give its prior consent before the assets can be sold for more than the reserve price of a failed auction. Legally, any property transfer made by the business after liquidation has started without the consent of the liquidator is typically deemed null and void. However, transfers made to a legitimate buyer for a fair price in the regular course of business may occasionally be permitted. Next, we will study that what are the usual methods for transferring property during liquidation. First one is public auction. The company's assets are typically sold at an open public auction. The liquidator does so in order to realize an augmented value of the property to be sold so as to be able to guarantee equity for all its creditors. Next option is a private sale. In some specific circumstances, the liquidator may be permitted to trade company's assets through a private sale. This, however, is dependent upon court approvals and open procedures. Another option is creditor's claims. A creditor having a secured interest in a company's assets can make claims on it during the entire liquidation process. If such a property is transferred without his authorization, he has the right to proceed legally against the corporation to retrieve the asset and challenge the process as an attempt to transfer assets without the liquidator's approval. Thus, we can say that in India, transferring property to a company requires thorough work, including detailed preparation, proper and detailed paperwork and documentation, and observance of legal procedures. A seamless and legally sound transfer is ensured by appropriate due diligence and adherence to established protocols. This was all about transfer of property to and by companies. See you in the next lecture. Till then, thank you and goodbye.